So the judge sentenced Young to life in prison without the possibility of parole. He is appealing, by the way, criminal defense attorney and former prosecutor Dan Conaway with us now. So Dan, I want to ask you about what the prosecutor in this case, Howard Cummings, says. Two things I want to ask you about. First of all, do you think it's true that his conviction is only threatened in an appeal situation, or could this trial be called for misconduct?
I think it's more likely to be an appeal issue because at this point the trial's over, the verdict's in. What you would do first as a defense attorney in this situation is file a motion for a new trial. And that would be heard by this judge, by the trial judge, and who heard the entire case. And so in that respect, you may never get to the Court of Appeals because this trial judge may agree that there's been irreparable prejudice. Irreparable prejudice is the legal term used in this situation to the case, and therefore it must be retried. If the judge denies the motion for a new trial from the defense, and I'm assuming the defense will file one in this situation, then that would be ruled upon by the Court of Appeals, and then they would get involved.
Okay. Well, the prosecutor also called these allegations just junk. Is something like this, especially in today's day of social media, is this just junk? Is it common?
No, it's not just junk. And I'm a former prosecutor, so look, it's not junk at all. This has to be taken deadly seriously. And as we discussed earlier on the show, I mean, this social media stuff, we cannot have this infect the jury deliberation process. And that is for both sides. It's not just a defense issue. It's not just a prosecution issue. It's an issue for both sides because you never know what somebody's going to be saying on one of these sites. And that's why we have jury deliberations. That's why we have the rule of sequestration. That's why the jurors sit in a room closed off with a bailiff, a guard, sitting in front of the door to make sure that nobody comes in or out so that they're not affected by outside influences and they're only looking at facts in evidence. And, you know, we just saw in this case, Christy, where this whole argument about what evidence can come in, the sort of the painstaking steps that the prosecutor has to go through to present each piece of evidence. And the same holds true for the defense when you're presenting evidence. So we have very specific rules so that the jurors base their decision upon evidence and upon their own private deliberations, not outside influences. And so we have to keep the social media out. Otherwise, you taint the entire jury system. So this issue is not junk, with all due respect to this prosecutor. This issue goes to the very heart and soul of our jury system. It's that simple.
But how do you protect our jurors? Do you foresee in the future, because of this new social media age that we're in, that at least during deliberations, we're going to see more and more of them sequestered during that time? Because remember, during this trial, they started deliberations in the Jason Young trial on Friday. They went home for the weekend and they came back on Monday, and that's when they finished up. Had they been sequestered, might we not even be talking about this right now?
It's very true, and you really have to balance. You have to balance two things. One, the freedom of the jurors, and respect for the jurors as citizens to follow the judge's rules. And if you follow the judge's rules, then this is not an issue, because the judge, without a doubt, in every single case I've ever been involved in the same way, the judge makes it clear over and over and over again that the jury is not to be bothered, the jury is not to talk to anyone else about the case, the jury is not to tweet, to text, to Facebook, to look up things on the internet, to do their own independent research, so forth, so forth, so forth. So it's very clear. The question is, will the jurors respect it? And what's really a shame here, at least in this case, and again, just based upon what we know so far, or we believe we know, I should say, is that maybe this was just one juror. Well, you have 12, and so you have 11 following the rules, apparently, and then one who's not. And you hate to have to sequester jurors, take them away from their families, you know, put them in a hotel room every night, especially during a long trial, or even during deliberations that can sometimes take days, not hours. You hate to do that, but at some point, do you have to impose some type of sanction? Right. Maybe because we're also wrapped up in our BlackBerries and our computers and all this stuff. Maybe you do. I hope not, but maybe you do.
Let me ask you this. In this particular situation, This was a second trial for him. If this case gets thrown out, now granted he was found guilty, do you have to retry him a third time?
You don't have to. It's entirely up to the prosecution.
Would you?
I would not be surprised. I think if you're the prosecutor in this case, this is not, you know, this is a very, very serious case, as serious as you can get. I think with these facts, I think you really have to. And then you would make sure that all the safeguards are in place. Obviously, the next jury is going to have to be completely sequestered based upon this, at least for this trial, I would argue. But I think you have to as a prosecutor. I don't see how you're not as a prosecution. At the same time, obviously, on the defense, if the judge finds irreparable prejudice to the case and calls for a new trial, then you go nuts, you know, and you really take what this mountain of circumstantial evidence is and you attempt to whittle it down in the next case. But I would see a retrial of this case.
Oh my goodness, I can't imagine what that would do to that community. Thank you so much, Dan. Appreciate it. Dan Conaway, so glad you're here with us here. We're hearing, I want to let you know about another social media, or how social media has affected another trial. According to the Wall Street Journal,